What I was trying to do, my Lord, was to draw a distinction between where the court is trying to stop something that potentially may happen, and with it happening, there would be a violation of the Constitution. Here, we have a legislative process, a referendum process, that is inchoate. And it's like saying that the court has issued an order to the Speaker of Parliament. A political process must be permitted to evolve politically. And a judicial intervention commends itself where that process is complete and a legal product exists to which the judges then say, this cannot be allowed to stand. Let me give you an example. One of the proposed changes is to bring in a judicial ombudsman. I personally don't know whether that is good or bad or whatever. But I can possibly see a day, if this referendum was successful, where somebody would come and say, I am attacking only that section, because as it reads now, it is inconsistent with that section, and it undermines that framework. That would be a jurisdiction that I personally would entertain and would say the judges are the best people to speak about that. So, to my very humble view, the judges exercised a jurisdiction that the people of Kenya reserved for the Supreme Court. Only the Supreme Court of Kenya can issue an advisory opinion. The High Court decided to give an advisory opinion. Above all else, therefore, my Lord, I say that this judgment cannot be allowed to stand. It violates so many fundamental tenets of good constitutional interpretation and management of constitutional conflict that if it were allowed to stand, it will be the recipe for chaos.
Then what is of concern to us is that ultimately the finding is on the question of the quorum itself. In fact, when they make their final determination, it is on the question of quorum itself, which then is on all fours what Justice Okwanye had made a finding on. And that is the position or the point that my learned senior counsel professor was making.